the hearing and the appeal, the Queen on the application of Johnson, and the Secretary of State for the Home Department.
Mr. Strange.
My lady, before I continue with my submissions, I don't know whether my learned friend has handed up his supplementary bundle too. We've both tried to do our homework overnight, and we have put up two loose pieces of legislation which my learned friend has included in this bundle. So I would invite your lordships to discard my two loose copies and to take up the second supplementary volume which my learned friend has produced.
SV2.
That is
Yep.
SV2, yes, my lady. And you will see that has in it three pieces of legislation and the pleadings up to the grant of permission below, including my learned friend's skeleton. It doesn't have our skeleton, I make no complaint of that, but it's up to the grant of permission. So the court has, as I understand it, has a picture of how the claim got to where it got to by the time we got before Mr. Justice Dingham. But in terms of the three questions we were left with last night, can I perhaps take them in order and first deal with the question my Lady Hale raised about the Family Law Reform Act, and you will see this is in tab B of the supplementary volume. And I think we both anticipate that your ladyship was thinking of section 1 of the Act.
I was thinking of section 1 too.
Yeah.
Yes, my lady. But of course that is in this Act and enactments passed after the coming into force. So that doesn't include the 1981 British Nationality Act. And of course, unless the contrary intention appears. And of course, in section 50, subsection 9, it did. So at the time...
think it does, yes.
At the time, the view was taken that that doesn't assist in this context. It doesn't change the position under the British Nationality Act. But of course, as your ladyship rightly said, there's no coincidence about the adoption of the 1987 policy, which sought to give effect to the spirit of the Act, even if the Act wasn't amended. The second point, I think, was the question by my Lord Reid about Section 84 and the appellate rights. And you have Section 84 in tab C of this bundle. It is about 5 sheets from the back is probably the easiest way I can identify it. And that is Section 84 as it was in force between the 4th of April 2011 and the 7th of May 2013. And you will see then, subsection 1C, the decision is unlawful under Section 6 of the Human Rights Act. And again, under G, the removal of the appellant from the United Kingdom would be unlawful under Section 6 of the Human Rights Act. And it is on the basis of that I think both parties have taken the approach that the certificate aspect of the appeal really only focuses on the straight Article 8 claim rather than the Article 8 with 14 nationality. And then there was a third question by my Lord Toole.
Sorry, just working out what you mean there. So the argument that the appellant's argument that he falls within exception 1 in section 33 is based purely on his private life.
His private life and his family.
The question, the whole issue of his not qualifying for British citizenship because of the situation when he was born, it just doesn't bear on that at all.
My Lord, it certainly isn't capable of falling within the exception. So it, as an arguable breach of Article 14 and 8, can't trigger the exception because it can't be unlawful under Section 6 of the Human Rights Act. There is, of course, the argument my learned friend makes that it is an aspect of the historical injustice, and I'll have to address you on that.
Yeah.
And how far that is relevant to the straight Article 8 private/family life claim.
Yeah.
But the way
yes.
I think
you say that really that his the certification was right because his claim under Section 33 is hopeless. His appeal against on the basis of Section 33 is hopeless because the Secretary of State was bound to treat him because he's a foreign citizen and he's committed a relevant offence, she was bound to deport him under Section 32.
Well, it's not quite that, my lord. The way we would put it is because, of course, the exception is there in order to allow Article 8 in certain circumstances to override the mandatory form of Section 32.5. So I can't rely on the mandatory nature of Section 32.5 to override the exception. But what we do say is that his appeal would be hopeless in light of the way Article 8 has to be approached, as has been made clear in the case law and in Section 117C of the British Nationality Act.
Yes, but he's not challenging he's not seeking judicial review on the basis that that some balancing exercise between his private life and public policy in deportation of foreign criminals has been that exercise has been got wrong in some way or other.
No, my lord, but this of course is again taking a step back. This is a judicial review of the certificate of the Secretary of State. That, in fact, he has no prospects of success on that appeal at all, and therefore it is clearly unfounded. And his challenge is to that certificate saying that there is at least an arguable case. It is not clearly unfounded, and therefore he could make an Article 8 case. And we would say, in light of the way Article 8 has to be approached, and because it is limited to his pure Article 8 claim, private and family life, there's no prospect that he could succeed on such an appeal, and therefore the certificate was rightly upheld.
Can I just ask you about Exception 1?
My lord, yes.
I've opened it up in Mr. Southey's first black bundle yesterday, tab E. It's in one or two other places as well, but that's
Yes.
one place. That's Section 32. And have I correctly made a note of what you just said? Exception 1, which is in 33(2) over the page, where removal of a foreign criminal in pursuance of a deportation order would breach his convention rights. That, you say, can only mean what you call pure Article 8.
Yes, my lord.
Rather than Article 8 plus Article 14. In other words, can't be based on the contention that there is continuing discrimination.
Yes,
Why
my
do you
lord.
say that?
Yeah.
Because Section 84 only allows the tribunal to allow a human rights appeal if that removal would be contrary to in breach of Section 6 of the Human Rights Act.
I follow.
So it is the interplay between, which is, I think, where Lord Reed's question had its origin. It's the interplay between this and the fact that Section 84 only allows the tribunal to allow the appeal if the breach is contrary to Section 6 of the Human Rights Act. And because the debate we've been having yesterday, the Article 14 argument on any view cannot be.
Is caught by Section 6.2.
Yes.
Yes, got it. Thank you. I'm sorry to be...
And that's why we say this has to be focused on the pure article.
Okay, thank you.
On the pure article.
So on your approach, really, the only real issue in this case is whether a declaration of incompatibility ought to be made in respect of the legislation dealing with nationality, because so far as judicial review of the certificate is concerned, the appellant is bound to fail.
Well, that's what we say. He's bound to fail, and yes, we say that the only real issue is the first limb, the nationality aspect of the case, and there we say it fails for all the reasons we've set out. And of course, the difficulty you highlight is, and I think my Lady Hale highlighted yesterday, is that what is being sought is not actually in the strictest sense a declaration of incompatibility, because it's not yet, certainly to me, been identified which piece of legislation that is still on the statute book is incompatible. And of course, we know that Section 4 focuses on the legislation which is incompatible now, and it needs to declare that is incompatible. But there is no present day statute.
Well, if a provision in a statute continues to operate, even though it may not be on the statute book, do you say that you can't make a declaration of incompatibility?
My Lord, yes, we do, if it is no longer on the statute book. The only reason it operates is because, as we say, the operative date for determining a person's nationality is, in this case, 1985. Parliament has long replaced subsection 9 by one that is compatible with the Convention rights. And therefore we say, yes, you can't make a declaration of incompatibility in relation to a statutory provision which has long been replaced and is no longer, other than in a sense for historic interest, on the statute book.
Well, what relief? Let's suppose for the moment the appellant is right in his argument that he has been unlawfully discriminated against. What is the mechanism by which he can obtain redress?
Well, my Lord, that has been the conundrum I have been unable to answer because...
Well, there must be some redress, surely.
My Lord, I can see that, but I think both parties have struggled to identify, and various pieces of legislation have been sought to be identified in order to find a hook for a declaration of incompatibility if we got there. But in my respectful submission, ultimately...
I suppose we could make a declaration, not necessarily one of incompatibility.
I assume, in the last resort, that is the only mechanism left. But of course, it highlights the very difficulty with this case and with what we say is a challenge to a piece of legislation which operated at a point in time now some 31 years ago.
The 2014 Act is it which imposes on those who seek nationality via registration
My Lord.
the good character
It is.
test.
Yes, indeed.
There was a previous one in 2006, but that's now the 2014 Act, is that right?
Yes, it's the 2014 Act which incorporates that requirement to those who fall into the appellant's category
Quite.
now seek registration.
Specific 4I or whatever it is.
4I. Yes.
Yeah. Now, so that means, does it, that for someone who, because of the law as it was in 1985, didn't acquire nationality at birth, but if born now would, he falls subject to the good character requirement?
Well, my Lord, if born now, of course he would be a British citizen from birth and wouldn't need to register.
Exactly.
Yes.
But my Lord is getting to the point of saying,
Slowly.
is not the application of that good character requirement to this particular category of people, were the appellant's arguments to be correct, incompatible?
Well, first question is it capable of being discriminatory?
Well, that of course, that we would say it isn't, in part because, of course, it is certainly not a directly discriminatory requirement, because it applies, actually, it extends an application, a requirement that applies to everybody who seeks to register.
Yes.
Applies that also to this category of people. So it is a standard requirement which applies to everybody.
That we understand, yes. But of course, it could be incompatible insofar as it applies to the category of people to whom the appellant belongs.
My lady...
The people who were wrongly deprived of their citizenship at birth for discriminatory reasons.
My lady, I can see how that could be advanced. My lady, in our respectful submission, it is, however, in one sense, of course, more difficult because the focus, we say, because the focus is no longer on the group that is affected by this provision, is only a small subgroup, well, we assume a small subgroup of those who were unlawfully deprived, because it only captures those, it imposes the good character requirement. So it is only a small category of those, and we would say that requirement in itself is not discriminatory.
Well, that may go to justification, but the first question is, does it preserve a difference of treatment between, if you like, this claimant and somebody born on the same day whose mother was British?
My Lord, I can see that it is I hesitate to accept that it perpetuates
I'm not
it
sure that it does.
because, of course, it is all about the process of application for registration in order to remedy the defect, and therefore I hesitate to accept that it perpetuates it. But what I do have to accept that it continues to exclude a subcategory of those who were denied citizenship as of right by operation of the old section 50 subsection 9, the ability to regularise their status. But our submission would be, but that the causal factor there, and I've taken you through the way Parliament has sought to address this, the causal factor there is, or the operative factor there is the absence of good character, and not the illegitimacy. And we would say that is exemplified by the fact that this is extending a requirement that applies across the board to registration to this additional category of individuals.
Now, may I ask whether you say that point, that this is extending to this category a provision of general application to seeking people nationality by registration, takes it out of the ambit of Article 8 and 14 altogether, or are you putting it forward as a justification if it is within the ambit, or both?
My Lord, I would say both, for a reason I will have to come to, because, of course, yesterday I stopped at Carasif and ambit, and I will want to return to that for a minute, in a minute, if I may. But we say it goes to both.
Can I also just back up a minute, because I think a point seems luminously clear to everybody else, and I'm behind the curve on it. Section 6(2) excludes any claim under Section 6(1) where the authority was bound to act as the authority did. Section 32 of the Borders Act makes it mandatory for the Secretary of State to make a deportation order under subsection 5, but 33(2) has the exception. You have said that Article 8 can operate as an override via 33(2)(a) to the obligation under 32(5), but that Article 14, read with Article 8, can't operate as an override. I don't, at the moment, I just don't understand why that's so. Could you kindly explain?
Well, the way we get there is via Section 84 of the of the Nationality and Immigration Act.
Yes.
You have in tab C of the second supplemental bundle.
Yes.
And the fact that there, the grounds of appeal, the only grounds of appeal available, and the only grounds of appeal on which a tribunal can allow the appeal, are that a decision, we see that in 84(1)(c), is unlawful under Section 6 of the Human Rights Act.
As being incompatible with the convention rights. Now, why don't they include convention rights under Article 14, read with Article 8?
Because, my Lord, it is our case that by operation of Section 50, subsection 9, as in force at the time, the Secretary of State could not have acted differently to the way he then, I assume, acted in recognising, in not conferring nationality on, or citizenship on the appellant.
But then why is it that 8 can operate as an override, but not 14 with 8?
Because it's if I can call it that, it's a different 8. It's 8 relating to his current family life and his current private life, rather than Article 8 to his social identity in 1985.
But so is the Article 14 read with Article 8 argument, or one formulation of it, that is precisely directed towards his current status?
My Lord, ultimately, in my respectful submission, it probably falls back to the fact that the Article 14 argument cannot get over the Section 6 hurdle, while the Article 8 argument is deportation in the ordinary sense would be contrary to Article 8 in that it breaches his private and family life, is not struck by the same...
If the only impact of Article 14 is a historic one, then the road is plain. But what if that is not the only impact of Article 14?
As I indicated, my Lord, even if Article 14 were to bite today, having looked at all the statutory provisions, in my respectful submission, the Secretary of State could not have acted differently than to treat him as a foreign national for the purposes of Section 32(1), which is, of course, one of the requirements in order for the obligation under 32 to arise in the first place. She could not have acted differently, and therefore the Article 14 argument is incapable of overcoming the Section 6 hurdle, even if it were to bite today.
Well, thank you very much. You've explained to me how you put it.
Well, I mean, your point is that his status as a foreign national is determined by primary legislation.
Yes.
And if that's the situation, then Section 6 simply doesn't bite on that status.
My Lord, yes. Yes.
That's the argument.
My Lady, my Lord, can I then just deal with one question my Lord Toulson left me with yesterday about the good character requirement, and we've tried to dig back into the archives with limited success. I have here but only one copy of a 65-page 1988 policy in relation to the registration of minors under Section 3(1), which includes the policy we've been discussing, the 1987 policy, illegitimate children of British citizen fathers, which makes express reference to the Family Law Reform Act. And that also makes express reference to the need for good character, and in turn refers to something which I haven't been able to find, which is Annex E to Chapter 18, which sets out the standards of good character required for the grant of citizenship to an adult at the Secretary of State's discretion more generally. So there was in 1988 a stated policy on good character. We have, I haven't burdened your Ladyship, your Lordship with it, we have the current emanation of it, if your Ladyship, your Lordship would like it, but it is some 94 pages long and sets out in some detail the requirements. And of course they have changed. This is a policy that's effectively constantly being revised. But in relation to the question about good character policy and how far does it go back, that's what we've been able to find.
Thank you very much.
And of course, Section 40, just to add to that, that was the Secretary of State's policy in relation to the exercise of his or her discretion under Section 3. What Section 41A then did was, of course, turn that discretion into a mandatory refusal or a mandate not to allow unless satisfied that there's a good character. And we have Section 41 in the first supplemental volume at tab C, about 3 sheets in.
Yeah.
And you see now that says an application for registration must not be granted unless satisfied of a good character.
41A.
And I haven't, and again, I've only been able to do a relatively cursory search of Hansard, haven't found any references other than 2 references to the good character requirement in the debate of the 2014 Act, which added 4 G, H, and I to 41A, subsection 1.
And is the of documents which explain what the good character requirement amounts to in practice, are those departmental policy documents?
But they are departmental guidance, which is now on the internet. It wasn't, I understand, in 1988, but that, of course, was the very early days of the internet. And as I understand it, the Home Office doesn't think they went online until, at the earliest, the early 90s, but they were. So they're departmental guidance now in large parts on the internet. Can I then return briefly to the issue of ambit? And we were looking yesterday at Karasef, K&W, and Karasef, and the question whether Karasef and then Genovese amounted to a development of the law rather than a restatement of the law as it had always been. Can I just for one point ask your Ladyship, your Lordship, to go back to Karasef at Volume 5, tab 61, page 1995. And in particular, at page 2006, to just note the point, and this is a passage I think my Lord Hugh took me to yesterday, that having started with K&W where Article 8, nationality, acquisition of a citizenship was plainly outside the ambit, ratione materia of the Convention, we then move to Karasef where we see the reference to K&W and the reference to arbitrary denial, but we see at page 2006 that the court in fact left open the question of whether the complaint fell into the ambit. So rather than assert what on my learned friend's case would have been the obvious, the court there still hesitating to accept that actually even on those facts the complaint fell within the ambit of Article 8 so as to make Article 14 applicable. This is the penultimate paragraph on page 2006. From there, of course, we then move to Genovese in the development of the case law, and this is at the same volume, tab 54, MS 1879.
Sorry, I lost the reference.
Sorry, this is Volume 5, tab 54, MS 1879.
Thank you very much.
Oh, sorry, 1877 is where the report starts.
Got it.
And your Ladyship, your Lordship, have been taken to this in part. We have at page 1882, paragraph 27, the Dutch government's reference to K&W. And then we have at paragraph 30, in the second half, after footnote 6, the provisions of Article 8 do not, however, guarantee a right to acquire a particular nationality or citizenship. Nevertheless, the court has previously stated that it cannot rule out that an arbitrary denial of citizenship might in certain circumstances raise an issue under Article 8 because of the impact such denial on the private life of the individual. And we would respectfully submit, and that's, of course, the footnote to Karasef. But, of course, the first sentence is exactly what was held in K&W as it restated in Karasef. And the court then takes the next stage to consider at paragraph 31 whether this falls within the ambit of one or more of the articles of the Convention. And then concludes over the page that it did. But we would respectfully also note that, of course, the way the court expresses this at paragraph 32 where we see that it applies also to those additional rights falling within the general, for which the state has voluntarily decided to provide. This principle is well entrenched in the court's case law. And there, of course, that is effectively the point. The government there has provided for a right of registration, but does so only in relation to the for those who are legitimate, and does so on the basis which on its face is discriminatory on grounds of illegitimacy. And we of course see that in paragraphs 21 and again in paragraph 41. So in that case, as it might be said against me was the position here in 1985, on the face of the legislation as it applied to the decision on whether this individual was to be Maltese or not, the illegitimacy was the immediate and obvious basis for the actual decision, because it was at the heart of the statute.
Well, that's the same, exactly the same as here, isn't it?
Well, my lord, we say, and this goes back to the historic point, we say that might have been right in 1985. It is no longer, and there is actually no jurisdiction under the Human Rights Act to see whether the Act in 19...
Well, if the 1985 Act had not been amended or repealed, I mean, would there be any distinction between Genovese and the present case?
If the 1985 Act were to apply to somebody today, as it was then, it is difficult at the moment to see how it could, which is why so much of the argument in the written case certainly has focused on the fact that the law has long moved on and Parliament has done what it could in order to remedy.
Well, it hasn't moved on insofar as its continuing impact on the appellant is concerned. I mean, that's the real, as you put it, conundrum here.
My lord, yes, it is, and I have to accept that. But that creates the legal conundrum that it has done so. We say by reference to a decision the law made, actually no person made, the law made in 1985, that for reasons of the law he was not a British citizen, and that is a decision which is made at the time. And subject to him changing it or rectifying it afterwards, as he could have done, is the decision that informs for the rest of his life what his social state is in terms of nationality or citizenship is.
As if you would say, I suppose, he'd been denied an inheritance in 1985, he still wouldn't have the assets now, but you would say it was over and done with. Would you?
Well, it's certainly not over and done with so far as he's concerned, is it?
No. I assume in relation to inheritance, it depends on how the law had developed afterwards. Because one can see that there are all kinds of difficulties in terms of but one can see the same kind of difficulties of opening up an inheritance again 30 years later.
It might be inheritance on intestacy to which illegitimacy in the past was a bar and now isn't.
My lord, yes.
I know that might be true. I don't know whether I expect it is.
My lord, I don't know either, which is probably why I hesitate. But it is, and of course, we will see that when we look at Fabrice again, which my learned friend took you to, the inheritance case. Yeah. There, of course, it was again on the face of the legislation as applied by the courts in France that illegitimacy was the immediate and obvious basis for the actual decision that was under challenge. Which, of course, we say, here it isn't. And, of course, that also, we say, informs the my learned friend calls the but-for test, and the case law he relies on. Because if one looks at cases like James and Eastleigh Borough Council or the Crown against Birmingham City Council, ex parte EOC, all these familiar cases, of course, in all of them, the criterion used was on its face, obviously, and immediately discriminatory. In Eastleigh, it was the pension age, which was inherently discriminatory. In Birmingham City Council, it was the fact that there were fewer places for girls than for boys, and therefore the standards required to get into the school were higher. In my learned friend's Clift example, the policy was inherently discriminatory because it differentiated between men and women. While I have to accept, he ran the Clift example by reference to gender, as I recall it. Right. If I have that wrong, then I apologise. And the same is true of Abdul Aziz, and it's true of Ince. But that takes us back to the position here, that the operative decision before this court is the decision under Section 32 to deport a foreign criminal, in relation to which, as we've seen, as I hope I've shown through the development of the legislation and the policies that were able for him to rectify his status, etc., illegitimacy is not the immediate and obvious cause. It is the fact that he is a foreigner by operation of the law, and nobody has yet been able to identify any way in which, even if my learned friend were right, that fact could change and therefore undermine the Section 32 decision. Because even a declaration of incompatibility, if it could be made, of course, doesn't change the fact that at the time of the decision to make the deportation order, he was a foreign citizen, or he was not a British citizen. Can I, just in relation to this reference to the immediate and obvious basis for the actual decision, can I perhaps just ask the court to return to Fabrice briefly? It's volume 5, tab 53. It starts at MS 1844. But if I could ask your ladyship, your lordship, to turn first to 1861, to pick up in paragraph 52 a point I think my Lord Hughes made, that the basis there was that the decision was purely on account of his status as a child born of adultery, and therefore it is the immediate, obvious, and only basis for the decision. And we see that again in paragraph 61. Sorry, 62. At the bottom of the last sentence of 62, it is therefore not disputed that the only reason for the difference in treatment suffered by the applicant was the fact that he had been born outside marriage. And again, we see at paragraph 71 how even at the time of the decision, under challenge before the Strasbourg court, that discrimination was still very active. By contrast, of course, we have, even in the domestic case law, those cases where the discrimination or the discriminatory ground is not the obvious and immediate operative ground. And we see that in Crown on the application of E against the governing body of the JFC, the court's reference, volume 3, tab 31 at MS. And of course, in the Nagarajan decision, Volume 2, Tab 24. Can I perhaps just ask the Court to turn that up briefly? Volume 2, Tab 24, MS 762. And these will, of course, all be terribly familiar to the Court. But can I just draw attention again to the speech of Lord Nichols, starting at page 773. By the letter H. Decisions are frequently reached for more than one reason. Discrimination may be on a racial ground even though it is not the sole ground. A variety of phrases with different shades of meaning have been used to explain how the legislation applies in such cases. Requires that racial grounds where a cause, the activating cause, a substantial or effective cause, a substantial reason, an important factor. No one phrase is obviously preferable to all the others, although in the application of this legislation, legalistic phrases as well as subtle distinctions are better avoided so far as possible. If racial grounds or protected acts had a significant influence on the outcome, discrimination is made out. Read in context, that was the Industrial Tribunal's finding in the present case. The tribunal found that the interviewers were consciously or subconsciously influenced by the fact that the applicant had previously brought tribunal proceedings against LRT. And we would respectfully submit that in that line of phrases which Lord Nichols identifies, is certainly not inconsistent with the phrase immediate cause used by the Court of Appeal in paragraph 34 of its decision.
Well, I think there's a big difference between significant influence and immediate cause.
My lady, there are, of course, as Lord Nichols put it, there are the activating cause. If one picked that out of the lineup Lord Nichols put up, is probably, in my respectful submission, not as far away from the immediate cause as the one your ladyship put to me. But I can see that. But in our respectful submission, avoiding, as Lord Nichols put it, legalistic phrases, the criticism of the Court of Appeal's approach, in my respectful submission, is unwarranted in light of the indication given in the case law of the correct approach to cases where the prohibited ground is not the obvious and immediate or inherent, the obvious or immediate basis for the decision. And of course, again, we come back to the fact that the decision in issue here is the Section 32 decision to deport the appellant.
Mr. Riker, could I just mention, I don't expect you to answer this just now, but just while, as you mentioned Section 32, I raised yesterday the curious fact, as it seemed at first sight, that Exception 1 isn't qualified in the way in which Section 6 of the Human Rights Act is qualified. And your answer to that really was to point us to the grounds of appeal, where reference is made to Section 6 of the Human Rights Act. Now, I notice that the grounds of appeal are not by any means, of course, confined to breaches of Section 6 of the Human Rights Act. They include that the decision is not in accordance with immigration rules and that the decision is otherwise not in accordance with the law. Now, the immigration rules themselves state, I appreciate I have the advantage of you because I have them in front of me. Rule 397 says that a deportation order will not be made if the person's removal pursuant to the order would be contrary to the UK's obligations under the Human Rights Convention. So that's not qualified by reference to anything like Section 6.2 of the Human Rights Act. It follows the same, it's more or less the same language as Exception 1. And deportation in breach of that rule would be susceptible to appeal on the basis that the decision is not in accordance with the immigration rules, on the face of things.
Well, my Lord, I would have to look at...
Yeah,
I don't have the immigration rules with me, and I don't know
appreciate
whether...
that. I'm simply wanting to raise the matter during the course of the hearing so that it's been raised. I appreciate it's an important point because, if a point is well made, it means that Parliament, in enacting the 2007 Act, has gone further than it went in the Human Rights Act. But we need to raise it since evidently the scope of exception 1 is clearly an important aspect of this.
My Lord, yes, and I will have to, as I indicated, I will have to look at that and have a look at the... yeah. Can I then... So coming back to the point I was seeking to make, the decision here, of course, is one that if it differentiates at all, inherently and obviously, it is between British citizens and non-British citizens, and I've made the point that that's not unlawful discrimination, but it doesn't inherently and obviously discriminate on grounds of illegitimacy, and therefore. We would respectfully submit that the Court of Appeal was right in its decision it reached, but also we would submit, if contrary to our submissions, the Immigration Act 2014 felt to be considered, and we discussed this earlier, felt to be considered as now a source of unlawful discrimination. In our respectful submission, there are two provisions to look at. One is Section 65, which provides the new Section 4I, etc., in order the power to register. And that, of course, on its face is wholly enabling, covers everybody and is not discriminatory at all. So the focus would have to be on Section 41A. And again, here, and I made that point earlier in response to, I think, your Ladyship's question, even 41A on its face applies a duty to consider good character applicable to virtually all registration powers provided to the Secretary of State, and extends that power also to those who seek registration under the new Section 4I, which again we would respectfully submit does not obviously, at least not on its face, discriminate on grounds of illegitimacy, even though I'm conscious that it is, if one narrows it down to the inclusion of Section 4I, it covers and we don't know how big, a subgroup of those who did not benefit from the acquisition of nationality under the original 1981 Act, but of course only a subgroup, so certainly not solely by reference to illegitimacy, because one assumes a part of that group are well able to use 4I because they would satisfy the good character requirement.
Ms. Acker, I appreciate your advance in relation to this two arguments which fit together. If one's looking at it in justification terms, which you say you don't get to because it's not within the ambit, you say, firstly, the general provision is okay, and one mustn't strain the mesh too finely because it happens to cover this small subgroup. And secondly, you say that decisions on citizenship are par excellence matters of social judgment, where the respect should be given by the courts unless the decision is manifestly without reasonable foundation, albeit it's got to be subjected to close scrutiny. Got those 2 points. But if you are driven to say, advancing a suggested reason why it is reasonable, I say reasonable bearing in mind the word in Humphreys, why it is reasonable to require somebody who is illegitimate to show good character, where you don't require it of somebody who's legitimate. I mean, what is the reason?
My Lord, in my respectful, looking at section 41A, in my respectful submission, that question doesn't arise because, of course, section 41A requires good character of anybody who applies to be registered.
I understand that.
Including those who are legitimate.
If misguidedly somebody were to be persuaded to think that it might be a relevant question, is there an answer which you would like them to consider?
But, my Lord, there I can then only set out the reasons we set out in our printed case, that Parliament has taken the view that in order to assume British nationality for any person by virtue of registration or naturalisation are required to be of good character. So much so that they've made it a mandatory requirement. I can't really take that much further.
Very much.
If you don't get it at birth, and you're coming later, they're entitled to look at the kind of person you are.
Yes, my Lord. And of course that comes, and we looked at this briefly yesterday, of course comes, these developments in the law, of course, come with the other end, the extension of the powers, my lady observed it yesterday, the extension of the powers to deprive people of their citizenship, which goes now much further than only those who have obtained it by naturalisation, and under certain circumstances can include any British citizen. And it is, whatever one may think of that as a development, it is a reflection of the fact that Parliament has taken a view that nationality comes with rights and responsibilities, and you confer the benefit of citizenship only to those who are willing and have shown able to engage with those.
However, what we're positing is a situation of somebody wrongly denied citizenship at birth because of an unjustifiably discriminatory law, to whom an olive branch has been handed in the shape of the obtaining of citizenship by registration, to which is applied a criterion which is not applied to those who get it at birth.
My lady, I accept that, but
and you say that because the person was wrongly deprived of it earlier, the state is entitled to ask of him something which it wouldn't have asked if he hadn't been wrongly deprived.
my lady, I don't quite put it like that because, of course, our primary submission is that in 1985 it wasn't unlawful.
I know that, but we are being, we were playing the fool here and rejecting your argument for the sake of this argument.
I find it difficult to engage with that, but yes, that I can see that if today's standards applied and it were therefore an unacceptably unlawful position, then I don't think I can take it much further than say, one, A, that isn't our case, and two, Parliament has decided that that actually the Secretary of State has no discretion but has to refuse or cannot grant unless satisfied that they are of good character. And I've sought to set out as far as I legitimately can, I hope, what I understand the rationale for that to be. But that is, we say, clearly reflected in the development of the nationality law as it has occurred over the last few decades. But of course, again, and perhaps I can do this relatively shortly, in our primary case, as I've set out, is that this is, of course, a historic decision, and you have our written case that because it is a historic decision which operates only at the date of birth, that even if there had been, and our case is there hasn't been, but even if there had been unlawful discrimination contrary to the ECHR when it occurred in 1985, we say it is not, for want of a better word, justiciable under the Human Rights Act because of the operation of Section 22, subsection 4, because it doesn't doesn't have retrospective effect. And there, of course, we come into the distinction drawn by this court, and the House of, I can't remember, was it the House of Lords and McKerr, between the rights under the Convention and the rights under the Act, and there just weren't any rights under the Act that were engaged for him. And we would note that one, of course, when one looks at the post-McKerr decisions, they, in our respectful submission, made absolutely clear that the reason Article 2 was engaged there was because of the existence of the severable and freestanding procedural obligation under Article 2 to conduct an investigation, and was only concerned with that procedural obligation rather than the substantive obligation under Article 2, which might have been violated in the past. And we submit, the contrary has been argued, there is a freestanding or severable obligation under Article 8 or under Article 14, either procedural, which wouldn't assist my learned friend anyway, or even less, as he seeks it, a substantive, freestanding, substantive obligation to rectify past discrimination. No such right is provided for by the Convention. I won't, unless your lordships, ladyship, your lordships want me to address those cases in detail. You have our printed case, and my learned friend, of course, in his submissions yesterday, tied his submissions very firmly to the existence of a continuing act or continuous activities. But our case is that that's plainly not relevant, because here this was plainly a historic decision and not a continuous act for the purposes of the Convention.
I'm not sure I entirely follow why you say that. If you look at the property cases purely to highlight a distinction, one can see that cases where there has been a one-off act of expropriation are treated as not continuing acts, although they may have continuing consequences. But on the other hand, in the Cyprus case, where the court said that the supposed government of North Cyprus wasn't recognised as a legal entity, and therefore the expropriation had no effect as a matter of law, there was a continuing interference because they were a continuing owner. Transposing the same thinking to status cases requires a more nuanced approach, does it not? Now, you may say that you can identify a past act as a one-off act, but you can't, it seems to me, necessarily say, and therefore there is no continuing effect. Supposing that somebody is refused a spousal visa on the basis that they're of different ethnic origin and the state doesn't recognize mixed marriages, that refusal of that visa would be a one-off act. But a continuing law that prevented that person from ever coming to this country under a spousal visa would it not a continuing interference?
My lord, in our respectful submission, not by its mere existence, no.
Although you had a law on the statute book which says we don't recognise mixed marriages as marriages, that would not be a continuing potential interference with somebody's Article 8 rights.
No, my lord. But the scenario is
Maybe that's a false analogy. But as a matter of principle, you say that would not be a continuing interference.
No, my lord. I would not. I would say that is not a continuing interference,
right.
But its application to each individual case, of course, i.e., denying entry clearance on that basis in relation to that individual, would be. But of course, here that is a very different scenario to the one we have here, because the law as it applied no longer is on the statute book. So whatever, if that was unlawful discrimination, and we say it wasn't at the time, but if it was, it is no longer in existence, and therefore no application of that law has happened since.
No, I follow that. But I intervened to raise the point for this reason, that your argument has been very much structured along the lines, this is a one-off event that happened in 1985. We are not concerned with continuing interference. Yes, and I'm simply signalling that I'm not necessarily persuaded at the moment that that is the correct analysis. I wanted to hear you on it, but you've said what you have to say.
Yes, my Lord. I'm grateful. We also say, in relation to what I said a minute ago about the absence of an obligation to correct past illegalities, if one wants to call it that, we also, of course, draw support from, and you have this in our case at paragraphs 37 to 44, the case law on legal certainty in the European Convention on Human Rights. And can I just give you the references? The first one is Marx, Volume 6, tab 66, MS 2194, in particular paragraph 58 on page 2217, which of course made clear that having now found a violation, the Belgian government was not required to reopen past applications of that now unlawful law in order to rectify the position and interfere with the civil status of the individuals before. And the same is in PB and JS at Volume 6, if I could just perhaps briefly ask your Ladyship, your Lordship, to take that up. Volume 6, tab 73. And we see that again, in particular, at page 2381. And this was about access to the Civil Servants Insurance Corporation in Austria for a homosexual partner of a serving civil servant. And we see in paragraph 46 that the applicant submitted in the last sentence that they were also victims of discrimination because persons to whom the extension of insurance cover had been granted before the entry into force of the amendment continued to benefit from an extension of the insurance cover. And then at the end of paragraph 48, last sentence, the court cannot find that it is incompatible with the requirements of Article 14 for those who have previously been entitled to a specific benefit under the law in force at the time to be given sufficient time to adapt to changing circumstances. In this context, the court notes its case law, according to which the principle of legal certainty, which is necessarily inherent in the law of the Convention, may dispense states from questioning legal acts or situations that antedate judgments of the court declaring domestic legislation incompatible with the Convention. The same considerations apply where the Constitutional Court annuls domestic legislation as being unconstitutional. And we say that applies in the same way where Parliament has clearly recognised that something needed to be done and amended Section 50, subsection 9, forward-looking to enable those born after 1st of July 2006 to automatically acquire citizenship, and all the other aspects the Secretary of State and Parliament have adopted to mitigate the impact of the old Section 50, subsection 9. But there is, as a matter of convention law, no positive obligation on the state to remedy the situation of all those affected by the operation of the previous law, now found incompatible.
But is this a specific dispensation, i.e. exception, to what would otherwise be the case? That's certainly the language used in Marx, talking about saying, the court basically dispenses with any obligation on the Belgian government to put right historic problems.
It is right that there, of course, it was in response to a specific issue about the problems that might create, raised by the by the Belgian government. I accept that. But we see, of course, in PB that passage I just read to you, my lady, is footnoted to refer to marks at paragraph 58. This is footnote 17. And it is therefore the application of that principle stated in more general terms. But even if it weren't, in our respectful submission, the problems highlighted and addressed by the court in the Marx case and accepted by the court in the Austrian case here, we would respectfully submit equally apply here, where all the issues about automatically conferring nationality retrospectively on people who know they had it, etc., which have motivated Parliament and the Secretary of State throughout, are such that to give it retrospective effect, just as to change the status of the relationship between children and their mothers pre-Marx in Belgium, is such that the same principle should apply. My lady, can I then briefly, very conscious of the time, look at, I think I've dealt with ambit, when we say in looking at Karasef and the absence of an objective and immediate cause being illegitimacy. It's neither within the ambit nor, if it were, is it unlawful because it can be justified. In terms of relief, again, I think in response to questions at the outset of today's hearing, I made clear that in our respectful submission there is, hasn't yet been identified, apart from what's been suggested to me from the bench about Section 41A, or a sub-part of Section 41A of the 2014 Act, a specific statute which could be the subject of a declaration of incompatibility. And we make that submission on the basis that Section 4 is expressed to be in the present tense, and it relates to legislation which is currently on the statute book, we say. And that, of course, has to be read in combination with the fact that under Section 6, the failure to lay any or an adequate proposal for legislation before Parliament is not an act for the purposes of the Human Rights Act, which could be subject to criticism on the basis of non-compliance. And that really leads us to the issue of the certificate. And again, in the exchange this morning, I made clear that our position is that this really is focused on what I call the pure Article 8 case, namely his current private life and his current family life for what it is in relation to the interference his removal would have to that. And in our respectful submission, that is, there's really no prospect of such an appeal to be successful. Can I just make 3 points to try and make that good? The first is my learned friend's reliance on Gurung. For your lordship, ladyship, to your lordship's reference, this is volume 3, tab 32 at MS 1016. And of course, in that case, the historic injustice at paragraph 2 was that the Gurkhas were completely excluded from the right to settle here. And the test that was applied was effectively that if they could show that they would have settled here if permitted, then that was an important factor to be considered in the context of Article 8. That, of course, doesn't apply in the same sense here. And again, I of course, accept that Section 50, subsection 9 prevented the appellant from automatically obtaining British citizenship. But, of course, he was not prevented from obtaining it, because the 1987 policy would not only have enabled him to apply, but on the findings of the courts below, he would have been successful in getting British citizenship. And
How
therefore,
much does it cost to become registered as a British citizen?
I would have to check, my lord, what the fee is today. I don't know what the fee would have been between 1987 and 19...
Is it about £700 at the moment?
2002.
I think the price has just gone up, I'm told, but I don't know, my lord, is the answer. But certainly in 1987, I would have to make inquiries, my lord.
Yeah.
I don't know, but
It's not important, Mr.
we have the findings below that he could have made the application and he would have been successful.
Yeah.
And insofar, therefore, as Section 59 is operative, Section 50, subsection 9 is operative, as my learned friend calls a historic injustice. It is in a much milder form, if I can call it that, than it was in Gurung, where there was an absolute, effectively a policy which absolutely excluded them from benefiting from the right of those who've served for Her Majesty to settle in the United Kingdom. The second point we would make is that, of course, Parliament has made clear increasingly how high the hurdle is to overcome in order to be successful on an Article 8 claim in the proportionality assessment. And perhaps, again, in view of the time, if I could just give you the reference to the two cases, MF Nigeria, Volume 2, Tab 22, MS 709, in particular at MS 725, paragraphs 41 to 44, and Chieri at Volume 3, Tab 33, MS 1040, and in particular 1053, paragraphs 42 to 44. And then can I just... So that's the case law reflecting on how the high hurdle that has to be overcome in order to succeed on Article 8. One final reference to the statute. Could I ask the Court to turn up Volume 1, Tab 7, and this is really my last point, page MS 239, Section 117C. Of course, if the appeal were to be heard, if the certificate were quashed and therefore the appeal would be heard now, this would apply, Article 8, additional considerations in cases involving foreign criminals, to the more serious the offence committed, the greater is the public interest in deportation. And then we see in 3, in cases of a foreign criminal not sentenced to a period of 4 years or more, the public interest requires cease deportation unless exception 1 or 2 applies, and we see those set out in 4 and 5. But subsection 6 makes clear, in the case of a foreign criminal who has been sentenced to a period of imprisonment of at least 4 years, the public interest requires deportation unless there are very compelling circumstances over and above those described in exception 1 and 2. And we would respectfully submit that applying that test and taking into account, so far as we can, the findings of the first tier tribunal summarised at paragraph 67 of our case, it's page MS 112, and the findings of Mr. Justice Dingerman at paragraph 11, MS 120, we would respectfully submit that there can be no reasonable doubt that any appeal purely on Article 8 grounds would fail, because on the one hand, there's no evidence that exceptions 1 or 2 apply in section 117, and even less that there are very compelling circumstances over and above those described therein. And it is really for all those submissions that we would invite this Court to uphold the decisions of the Court of Appeal with costs.
Only one point. We've now got what stands for a pleading and which asks for a form of declaration of incompatibility. It's the latest supplemental bundle at divider M, internal 17, paragraph 67, talks about declaration of incompatibility in relation to section 9. Well, we've seen that of the 2002 Act, and or 162.5 of the 2002 Act, I don't know if that's a typo, but I don't think we've seen that.
We have. I did take you to section 162.
Did you? I'm sorry.
Which is at. It's volume 1,
Yeah.
tab 7,
Yeah.
page 242.
Oh, thank you so much.
And that, of course, then.
Yep.
And the date is in the next
Yep,
tab.
I got you. Thank you.
And the submissions we made in relation to that was that if that were the case, then of course it would still be a question of him registering, and again, looking at the decision under appeal, it wouldn't assist in relation to changing the fact that he was a foreign national at the time the decision was made.
Thank you.
My lady, my lords, unless I can assist the court further, those are the submissions on behalf of the Secretary of State.
It sounds as if you've given us all the assistance that you can. Thank you very much, Mr. Riley. Mr. Brown?
My lady, my lords, can I just briefly sort of come back to the point, in fact, my Lord Toulson just made a moment ago about the procedural history. We dug up overnight the claim form and grounds, which did develop rather with time for several reasons, not least the fact that when the claim form was first issued, in fact, there hadn't been a decision on the Article 14 case, and as a result, there hadn't been any decision as to whether or not the case was clearly unfounded. Just for my Lord's notes, I don't think anything turns on this. In fact, although I'd asked for the skeleton to be included because my memory was that had stood as amended grounds, there had actually been a formal application to amend the grounds, which was essentially in the same terms as the skeleton argument. The amended grounds are, in fact, with the application notice at tab L, and they are the set of grounds that Mr. Justice Hayden granted permission to the claimant, or the claimant as he was then, to rely upon, and that order is at tab N. I don't think anything turns on the difference between the skeleton, but it is, I think, just for the sake of accuracy, if one goes to the top of the page, there's page numbering, I think, from the original bundle at 199A and 200, one sees the same paragraph. Can I then turn to the submissions on my learned friend that my learned friend made yesterday and today? My learned friend started by setting out the history, really, of the attempts to address the situation of people born illegitimate. It's important in our submission to recognise two things about that. The first is, of course, that is an implicit recognition that there was and is a problem, and it's also an implicit recognition that there is no justification for discriminating in this area. The Secretary of State has sought to reduce that discrimination. Unfortunately, what has happened is that at all stages, the discrimination hasn't been eliminated. To look at, for example, the policy that applied from 1987, the key point was that an application needed to be made before 18. That put the burden essentially on someone's parents to take action. One wouldn't necessarily accept a child would be aware of the significance of their status. And they were in, as a result, a very different position to somebody who'd been born legitimate. Throughout, as I say, the changes, that has been a continuing feature. The fact that those born illegitimate are placed at a disadvantage. We continue to see that's the case in that under Section 65 there's the need for an application still, and there's a need to meet good character. So it's the application of additional thresholds in circumstances where they wouldn't apply if somebody had been born legitimate that continues to be a feature of this case. And that's the primary reason in our submission why reliance on the absence of any application, which is something my learned friend repeatedly replied upon, doesn't assist him, because it relies essentially on the discriminatory behaviour that is challenged. One particular point in that context I should address is that my learned friend said it's of some significance that there was no application for nationality before the decision to deport, and similarly said there'd been no decision to reject an application on good character grounds. In my submission, that can't be relevant because it's plain that any application made now or made after the age of 18 would have failed. There wasn't any provision for somebody who was an adult in the appellant's position to obtain citizenship. He can't be expected to make an application that would be bound to fail. My learned friend then says that essentially what is demonstrated by the various policies and statutory changes is that at all stages, essentially, status was decided either at birth or at a discrete date, such as registration. 2 points. Firstly, that doesn't determine whether or not there's a continuing breach of the Convention as the European Court uses that phrase. If one looks at Couric, for example, Couric was a situation where there was a discrete date, distinct date, when the individuals lost their resident status and when they were barred from applying for citizenship. But that distinct date didn't prevent the European Court concluding that there was a continuing breach of Article 8. And the reason why, in my submission, it's clear that the European Court found there was a continuing breach is because, essentially, it recognised that there was a continuing interference with the right to private life.
Can I ask you about Couric? Because it was lengthy, and I went back and read it again last night. Am I right in having understood that one of the reasons which was given, it's in Headnote 11 and thereafter in the text, why the court thought that there was a continuation in that case was that there had been rulings of the Constitutional Court in Slovenia requiring action, and as they said, for either 11 or 7 years, the case may be, there had been repeated failures to obey the orders of the court. Where does that fit in?
Well, it's true, certainly, that there were findings of violations. A couple of points I would make is that, firstly, and I'm speaking from memory because I again looked at this last night, but I am speaking from memory. The violations, in fact, were found after the convention had come into force.
Oh, absolutely.
Whereas the approach of the European Court seemed to be to if one looks at how it approached the continuing status, was not to start from the dates of those violations. It appeared to be to treat the whole period from the entry into force of the convention as a continuing breach. And the reason for that, in my submission, is it's clear when one looks at why it concluded Article 8 was engaged. It looked at Article 8 and concluded it was engaged for two reasons. Firstly, that there had been a failure to address the problems that were in place. I accept that. But equally importantly, it recognised that there was a continuing interference with private life because these people essentially had no status, and that was at the heart, in my submission, at the heart of it. It was and one way of testing that is to look at the other case, which
just before we do that, I mean, Couric, the Grand Chamber pretty much rubber stamped what the Chamber had decided.
Yes.
One therefore has to look at their recitation, what the Chamber decided, to see what's the core of the judgment.
Yes.
It seemed to me on rereading it that it's perhaps paragraph 337, which is MS 2067, which comes succinctly to that.
Sorry, which paragraph again?
337
sorry.
on 2067.
Yeah.
Yes. No.
They'd had a prior established family life, repercussions of the erasure and the prolonged refusal of the authorities to comprehensively regulate their situation constituted an interference.
Yes. Well, that's perhaps exactly, and I'd completely accept that is the key reasoning, and what I'd emphasise is the weight placed on the repercussions. And what the European Court, in my submission, is saying there is the fact that this has an impact on, or it had a very significant impact on the private life of the individuals. That's what it's talking about when it's talking about repercussions. And that's also consistent with the case that we submitted yesterday, which we haven't gone to in any great length, but is also of some value, which is the Valiantos case, which is at tab H, where the length of the European Court's reasoning in this is perhaps not great. But at the same time, in my submission, it fits with the approach in Keurig. Paragraph 54 is where the court talks about there being a continuing violation. It's another Grand Chamber decision, interestingly. It talks about there being a continuing violation of Article 14 and Article 8.
Paragraph?
It's paragraph 54.
Thank you.
Sorry.
I'm behind you. Divider again, sorry.
It's divider H of the first supplementary bundle.
Thanks.
This is a case about civil partnerships being confined to opposite-sex couples,
Yes, exactly.
and the complaint brought by same-sex couples.
Yes. And paragraph 54 is where the court, to some extent in an aside, described the complaint as being one of a continuing violation because there is an inability for same-sex couples to enter into.
But there's a current law preventing it, isn't there?
But exactly, and it goes to it's consistent with the point my Lord Toulson made, which is what I was also going to draw attention to, where my Lord Toulson used the example of a law that said you can't get entry clearance if you're in a mixed marriage, and said, and my learned friend's argument was, answer to that was to say that isn't a continuing breach. Yeah. Now we would say that is a continuing breach, as demonstrated by Valiantos, as demonstrated by Keurig, because both of those judgments demonstrate that if you have a law that interferes with your private life and continues in place, that is a continuing breach. And here we have a law that prevents the appellant enjoying the rights he would enjoy, which we would submit, and I'll come on to this, engage Article 8, and they prevent it on a ground that's discriminatory. And in our submission, there is no real reason for distinguishing between the approach, because it is, again, it's about a law that interferes with somebody's private life, particularly if one takes the approach in Genovese, which is to regard our private life as including social identity. Can I just move on from that? Just one other point about the policies. My learned friend says that the policies demonstrate that Parliament and the Secretary of State has consistently taken the position you can't automatically confer citizenship on people because of the risks of serious harm. Firstly, of course, Section 47 demonstrates that's not the case. Secondly, those issues would potentially apply at birth. But thirdly, even if that's right, and this is the real reason for addressing this, is that can't justify the good character requirement or the historic age requirements, even if it means there's a requirement to, there's a legitimate reason for requiring people to apply, and we don't accept there is. That can't justify the separate aspect of discrimination in this case, which is the imposition of other requirements, such as the good character requirement. And my learned friend accepts, essentially, Section 65, for example, continues to exclude some who were born illegitimate from the status that they would have obtained if they're legitimate. He says the absence of good character, essentially, is the reason for that. But that's, again, relying on a discriminatory factor. Case law, as my learned friend accepts, recognises the possibility of multiple causes for discrimination. And in our submission, to say, well, we've imposed a discriminatory factor and that then causes, that justifies the treatment, can't be right. Circular, in our submission, circular reasoning. Can I, actually just realised I took something slightly out of order because of answering the question. Can I deal briefly with Posty? Posty in my submission is a relatively rare case where the court has adopted this approach of not treating what might be described as a continuing situation as that. The reason in my submission why the European Court adopted that approach is because of the nature of the breach. The breach that was complained about wasn't about a right to fish, because there is no such right. It was about the right to property.
Yeah.
It was about the lease. And the lease gave fishermen a right to fish in a particular area. And what happened was the law changed that property at a discrete point in time. That's the distinction in my submission between the Kurik and the same-sex cases and Posti. Posti was about a property whose nature changed at a discrete point in time because of the law. The cases we rely upon, Kurik, etc., are about a situation where there's a law which continues to restrict people's private life.
Is the contrast between Posti and Loisidou explained in this way, that in Posti, the court treated on the facts the case as one where there had been an expropriation of a property right, which was not of itself, therefore, a continuing act. That which has been taken from you has been taken. But in contrast, in Loisidou, they did not treat it as an expropriation because they did not recognize the legal nature of the instrument which supposedly affected it. And because there had been, in their eyes, no act of expropriation, there simply remained a continuing interference.
Yes, yes, I'd agree with that entirely. And it demonstrates in my submission that if one's going to look at causation, one needs to look at whether or not the breach in the causation, essentially, which is, in some senses, was an issue there, was consistent with international law. Can I then turn to the issue of ambit and what were the applicable standards at birth? My learned friend started from K&W, and in some senses all in my submission I need to say in relation to that is to remind the court of my learned friend's response to Lord Kerr's question when he was asked to justify K&W. And in my submission, my learned friend struggled unsurprisingly. In my submission, what Karasef then did in terms of Article 8 was that it recognised what probably always needed to be a qualification to K&W. Obviously, the Convention doesn't, on the face of it, entitle anyone to citizenship, but the powers that the state exercises clearly have to be exercised in accordance with Article 8 and Article 14. And the qualification that, as a result, there needed to be decisions that were taken in a manner that wasn't arbitrary is hardly surprising. One of the points we make in our statement of case is that UN Human Rights Declaration predates K&W, obviously, by a considerable period, refers to how states shouldn't take citizenship decisions in an arbitrary manner.
Article 15.
Article 15.
Thank you for supplying the convention.
Thank you.
That's not a convention, I mean the declaration. Yep.
Sorry, Universal Declaration, yes,
Yeah.
sorry, yes.
I found Karasef really quite difficult in terms of the formulation of the principle. They said that it's necessary to consider whether the decisions disclose such arbitrariness or have such consequences as might raise issues under Article 8. And they decided it wasn't arbitrary, but they then went on to consider whether the consequences were such that taken separately or in combination with the refusal could be considered sufficiently serious to raise an issue. That was all in the context of Article 8 before they got to Article 14. And I was left in something of a muddle as to whether they were saying that you need to have arbitrariness plus consequences of sufficient seriousness to fall within the ambit, or whether either or suffice, and what exactly they meant by taking the consequences separately or in combination with refusal.
Well,
at the end of all that, I just found myself rather muddled.
I don't think you were unique, my lord, if I may say that in relation to that, not least because one of the things that we've saved the court, and maybe we should have supplied the court with, is that following Genovese, there have been a number of cases looking at Article 8 and nationality. They don't really assist the court because we're talking about Article 14 here, and that, in fact, has been the subject of considerable first instance litigation because of in terrorism cases where there has been denial of citizenship on grounds of good character. There are a whole, some of my lords or my lady may remember the AHK litigation, which is still sort of, which went to the Court of Appeal at some stage about special advocates, and which sort of raises this issue and which is still ongoing. But my lord, can I come? So there is a difficult issue in terms of Article 8. The critical point in my submission is that, of course, we're not concerned directly with Article 8. And Article 8 is an issue where, on any version of events, it's going to be more difficult to bring a claim arguing that a denial of citizenship is contrary to the Convention, because fundamentally states can decide who are their citizens. What they can't do is do it on a discriminatory manner. And that's why ambit, as was recognised in Genovese, is wider. And so, in my submission, what is the most important part about Karasev is the recognition that Article 8, unsurprisingly, given, as I say, the UN declaration, potentially came within the ambit of Article 8. And that, in my submission, is sufficient. It explains why, when you come to Genovese, the European Court had no problems deciding that the subject matter was such that Article 14 was in play. I mean, one of the problems with Karasev, I was going to make two other points about Karasev, is my learned friend focused on the fact that the European Court placed a lot of weight on the situation at time of birth. But in my submission, the reason for that, and it's one of the reasons it doesn't really assist, is because Finnish law prohibited dual citizenship at birth. So under Finnish law, if Mr. Karasev was a Russian national, the implication of that was he couldn't be a Finnish national. Which is what the European Court tended to think was the case, he then subsequently lost his Russian nationality. Well, the problem was probably one that should be directed at Russia, because that Russia was making him stateless, rather than Finland. Although one still needed to consider the consequences potentially, because the European Court was recognising that in some circumstances the consequences might possibly compel someone to be granted citizenship. So one sees in relation to Article 8 a sort of fairly complex set of circumstances where there's good reason for focusing on the situation at date of birth, because if he, in fact he was Russian at birth, then primary responsibility for his statelessness would be presumably Russia. I accept in terms of Article 14, the court just doesn't actually ultimately make any finding. But as I say, if one starts from the position as recognised in Genovese, that the ambit of an article is wider than the article itself, then it must logically follow from the fact that Article 8 can be violated by a denial of citizenship, that it's within the ambit. That then leads to Genovese, and I come back to the point I made. Nobody actually has identified in my submission any reason, unlike, for example, the position in relation to, say, transsexuals, why society's standards have changed in a material way. The European Court, if it is responding to changed standards, normally makes that clear. It will refer to international instruments that demonstrate a change in standards. It didn't in Genovese. Rather, what it did was identify how citizenship impacts on private life. It impacts in the way, firstly, that it relied upon in Genovese by impacting on someone's social identity, and secondly, it has the potential to impact on someone's family life. My learned friend seeks to distinguish Genovese on the basis that the illegitimacy was obvious on the face of the legislation. A couple of points I'd make about that. Firstly, it's difficult to see how that's relevant to ambit. It might be relevant to whether or not there's a justification, essentially, but on the face of it, it's not relevant to ambit. And secondly, we would submit this is a case where exactly the same factors apply here. If one was asked, one way of testing this is to look at the advice one would have to give if someone like Mr. Johnson came into one's office. How does one decide on his citizenship? One looks at Section 2. Section 2 says you can inherit citizenship from your father. You then need to read that in light of Section 50, subsection 50, subsection 9. And if you look at Section 50, subsection 9, you interpret that in light of the transition provisions. And they say, at today's date, if somebody was born before the cut-off date, as Mr. Johnson was, you apply the discriminatory term. And that's why the discriminatory provisions. That's why he continues to be denied citizenship. So this is a case where the illegitimacy is obvious on the face of the statute. That also links into the points that were made about whether or not this is a case where a declaration of incompatibility is appropriate. I know a friend referred a few times to legislation on the statute book, but of course, in some senses, that is a phrase that needs to be treated with care. If one looks at the statute book often applies different provisions to different people as a result of transition provisions. And here, it's the transition provisions that say, in Mr. Johnson's case, it's the historic version of Section 50, subsection 9 that applies. So it is, from Mr. Johnson's perspective, still on the statute book.
Well, what would the provision be that should be the subject of the declaration of incompatibility?
Well, we've identified, the language we've used is the continuing application of Section 50, subsection 9 in the case of those born before the date in question, because that is on the statute book for those people, and it's that prevents them obtaining citizenship.
Should the transitional provisions also be the subject of
well, that's where, in some senses, that's where we started from. The problem with the transition provisions is and we slightly modified our position, but that is where we actually started from.
Yeah.
And the problem with the transition provisions is that the transition provisions quite clearly anticipate that there will be a cut-off date. But if you say that if it's the transition provisions that are incompatible, you're effectively requiring Parliament to enact fresh legislation, because what the transition provisions are in some senses improving the situation. One way of putting this in simple terms, I suppose, is that transition provisions are improving the situation. They just don't go far enough by imposing a cut-off.
Where do you say that you've just spoken about the continuing application of Section 50, subsection 9.
Yes.
Well, what actually happened, unless I've misunderstood it, was that Section 50, subsection 9 was replaced by a new version.
Yes.
With effect from, or rather in relation to any child born after, in other words, with effect from the date which I think was in 2006. Doesn't mean, does it? Does that mean that the old 50, subsection 9 continues in some sense in force?
Well, yes, I mean, because, my Lord, I would draw a distinction between, I mean, my Lord I can't remember quite how my Lord put it, but my Lord used two different sets of language, which
Probably.
Yes, no, but equated them. And in my submission, with respect, one can't do that. One can have a provision which says subsection 50, subsection 9 means this from a particular date. That is deliberately not the language here, because if that's what the provision said, one would, going back to the sort of advice one would give Mr. Johnson, one would look at section 2, one would need to interpret it in light of section 50, subsection 9, and one would say, well, this is easy. You now meet the requirements for Section 2 because, as at today's date, father is defined in a way that you can meet or you can demonstrate is present in your case. It's not, the way in which the transition provisions are phrased is that they don't apply from a particular date, they apply to people born after a particular date. So that's why, as I say, it continues to apply in his case, because if you look at Section 2 and interpret Section 2 in light of Section 50, as one has to, in his case, one goes back to the old version. And so
In other words, your submission is that Section 50, subsection 9, does not apply to persons born after a certain date, but that doesn't rob it of its status as a provision of primary legislation.
Exactly.
Because it continues to apply to
Exactly.
people born before that date.
Exactly.
And indeed, it's the foundation of the disqualification for the appellant.
Exactly.
It has to continue as a provision.
Exactly, because if you were just to say the new Section 50, subsection 9, applies from a particular date, we wouldn't be here. Because you would look at Section 2 with the new provision and you would say, well, he meets the requirements because he has a father who is a British citizen.
But the section which confers the status isn't 59, either version 1 or version 2, is it? It's section 3.
Section 2.
2, I beg
Section 2.
I do beg your pardon. 2, of course, yes. 2.
Well, but of course, I mean, there is nothing inherently objectionable in Section 2. In that it talks about one's parents.
Yes, I see. You say it incorporates 59.
Yes, it's.
But since your claim was initiated,
Yes.
the legislation has moved on because, as you pointed out, Section 65 of the 2014 Act is now in force.
Yes,
And we've looked at that. Nobody suggested we shouldn't.
yes.
Now, you make an attack on that because you say that Section 65, read with Section 41A1 of the 1981 Act, is itself discriminatory because it imposes on somebody who's a child who's born out of wedlock a requirement of good conduct, character, which is not required of somebody otherwise.
Yes.
And that, so if you're seeking a declaration of incompatibility of current law, that I understand you to be asserting is incompatible.
Yes, but if one were to declare Section 65 incompatible, one wouldn't really be going to the heart of the problem, because one would still have on our sort of highest argument, one would still have discrimination between those born legitimate and illegitimate, because they would still need to make an application. They would still need to be registered, and so they would still be subject to differential treatment. Now, I've recognised that one possibly could say there is a justification for the registration process, but there's no justification for the good character requirement. The good character requirement in our submission has not been, there's no evidence really to justify that at all. In relation to the registration requirement, our learned friend's argument is there is a justification for that because it's potentially objectionable to give citizenship to people who may not want British citizenship.
Is the requirement that somebody should opt in rather than opt out a matter of such weight as to amount to a potential breach of the convention?
Well, it's still, the way in my submission that one looks at this, one goes back to the 5 questions, is one looks at whether or not denial of citizenship is of such weight, and that doesn't change, that's the same, whatever issue one's looking at. One looks at then whether or not there's a justification for that differential treatment, ignoring the other questions. And I accept it might be easier to justify an opt-in process than it is to justify the good character requirement.
Bearing in mind that we are in an area where considerable margin of appreciation is allowed to the government, not if it is simply unreasonable, but given that this potentially affects an unknown number of people, is there anything which can be stigmatized as unreasonable in saying that somebody wants a benefit, they should apply for it, rather than retrospectively apply it indiscriminately to a large number of people whose identities you don't know and who may or may not be interested in it?
Well, can I deal with that? There's a couple of points I'd say in response. Firstly, in terms of the margin of appreciation, obviously our position is that because this is illegitimacy, it's in fact a narrow margin of appreciation because one's talking about discrimination. Secondly, in our submission, I think I've already accepted, and I would accept that it's a lot easier potentially to justify the opt-in requirement.
Yeah.
I would still say, given the approach to illegitimacy and how objectionable that is, that's discriminatory. But I recognise that it would be open to the court to say the requirement of good character is objectionable. The requirement to opt in is not objectionable, and as a result, instead of the route to the route we've identified or the relief we've identified, then it would be the appropriate relief would be to declare Section 65 incompatible because, well, rather Section 41A.
41A, yeah.
Section 41A incompatible because that imposes the good character requirement.
Yeah. Well, it's the combination 65 and 41.
Yes, and from obviously from the appellant's point of view, that's satisfactory, and that deals with the concern that he's expressed.
Because the good character is a matter of substance, whereas whether you apply for it or get it automatically is essentially a matter of procedure.
Yes, and that's, as I say, in part why I've always why I've recognised it's much more difficult to justify the good character requirement than the opt-in requirement.
Well, there will be millions of people who have a nationality which they have acquired automatically, but they have never done anything about.
Yes.
My Lord has just given an example. Or at least I think it was yesterday he gave an example, and this morning we had a similar example given by Lord Dyson, who believes himself to be entitled to apply for a Bulgarian passport. Now, he doesn't have to register, one assumes, he just has to apply for a passport. So, in a way, that argument cuts both ways, doesn't it?
Yes.
It suggests that applying to register, providing registration is automatic and not vastly expensive, is not a big deal. And then you apply for your passport. But it's if it isn't automatic and it is a big deal and very expensive, something different.
Yes. Well, the other point, of course, is that, I think all I was hopefully conceding was that it may be easier to justify an application process.
That is exactly what you said.
Yes, and not anymore, because the other point I go back to, which is where I started from, is, of course, there is an inconsistency in the Secretary of State's approach in relation to this, in the sense that if one looks at the provision dealing with subsequent marriage, there's automatic British citizenship that follows from legitimisation through that route. And if it were objectionable, essentially, to confer citizenship automatically, it's difficult to see why Section 47 would operate in the way that it does. But it clearly can confer citizenship automatically. And the answer, if it is a problem that people obtain citizenship that they don't want, they can apply to renounce, because that's a route open to people. Can I then finally deal with Article 8? Firstly, one of the reasons, as I've made clear, that we have raised Article 8 is because there is a potential issue that arises if the Secretary of State is right that all one needs to consider is the situation at birth. That is the primary reason why we rely on Article 8, because it is a way, effectively, of relying on historic injustice. In our submission, it is relevant to proportionality, and that's a concept that doesn't depend on whether or not there's a breach of the European Convention on Human Rights. It doesn't depend upon whether the Secretary of State acted unlawfully contrary to Section 6 of the Human Rights Act. None of the cases on historic injustice have considered whether or not there was a breach of Section 6. They've essentially focused on what is now recognised by current moral standards to have been a sort of shameful part of Britain's past, something that should be frowned upon. But at the time, it undoubtedly was, or almost certainly was lawful, because it was justified in both the British BOC cases and the Gurkha cases by statute at the time. And as I say, that's why we potentially rely on this. This is if the Secretary of State is right, essentially, to say the Human Rights Act prevents any consideration of this because it was purely something that happened at birth, in our submission that still feeds into Article 8. The provisions of Section 117C in our submission are largely irrelevant because this is, on any version of events, a relatively exceptional case. Historic injustice is something that is in part addressed because why should the Secretary of State be able to effectively act in a way that they wouldn't have been able to if they'd behaved properly or behaved in accordance with current standards at the time in question. In terms of Article 14 and the clearly unfounded certificate, our concern remains essentially the terms of Section 84 and the fact that the appeal provisions clearly refer to Section 6. And our basic concern remains that the discrimination will not be eliminated unless the appellant is entitled to, through some route, nationality. That seems to be, that has always been our concern in terms of an appeal based on Article 14. One can address the symptoms of the discrimination, one can't necessarily address the cause. The only possible route we can see where Article 14 would be relied upon is if we're wrong in our primary argument that essentially this is a continuing situation and that there has been discrete acts. And if the discrete acts, such as the deportation, were individually a breach of Article 14, which is not our primary case, then there would obviously be an issue. And in fact, we raised that in our printed case. That would potentially lead to the quashing of the unfounded certificate. But if the fundamental point is Article 14 will remain breached until the appellant obtains nationality, then it's difficult to see how the appeal route can cure that because, as we've accepted, primary legislation prevents the grant of nationality. Anything else, Paul? Thank you. Thank you. Thank you. Unless the court has anything else it wishes me to address, then that should cover everything, hopefully. Thank you.
Well, Mr. Southey, according to my computer, you've timed that perfectly. I'm not sure about the clock in court. Maybe just a minute over. Well, thank you to everyone for the written and oral arguments which they have contributed in this extremely interesting and puzzling case. We will, of course, take some considerable time to decide what the answer is, but we'll let you know as soon as we have. Thank you. Court is now adjourned.